Okay, good afternoon, everybody. Welcome to the Litigation Center's Juvenile Justice event. Thank you so much for joining us. We have a great panel lined up for you. I'm Rachel Brockle, the director of the Litigation Center, and leading this event is Clodagh Mocklin, who's our Baxter Fellow. She's a graduate with the Litigation Center. She worked hard to put this panel together for you, and we couldn't be more excited about these topics because some of them are a little bit controversial, a little bit cutting edge, and just kind of delve deeper into the juvenile justice world in criminal practice. So I'm going to hand this over to Chloe, and Chloe's going to assist with having the introduction of the speakers and then also leading the panel with questions and topics. So we hope you enjoy this panel, and Chloe, take it away.
Hi, everyone. I wanted to start off by thanking you all for being here. We're excited to have these three panelists who come from a very diverse area and all who have worked in juvenile law here with us today to get all their perspectives on the topic. It's an interesting one. Before we get into introducing the panelists, though, I want to give you some reminders about how we typically run our seminars. So if you have a question that comes up during the panel, just go ahead and write it down and save it, and then we'll end a little bit early, so at about 10 minutes to 1, in order for you to be able to ask those questions. And at that time, you can either unmute yourself and ask the question, or if you don't feel comfortable, you can go ahead and private message it to me, and then I will ask it for you to the panelists. There will also be a raffle at the end, so stick around for that. We've come up with some prizes that are relevant to the topic today that will be fun, so make sure that you stay around for that if you're able to. And let's get into it. So first, we're going to have student volunteers read out the bios so that you guys can know our speakers, get to know our speakers a little bit better. We have Victoria, who will be reading the bio for Jen Redding. So Victoria, whenever you're ready, go ahead.
Jennifer Redding is a GGU alum, class of 2010, and currently an adjunct professor at GGU. She's also a deputy public defender for the County of Santa Clara, where she's currently on the research unit. Prior to being assigned to the research unit, she was on felony trials in the juvenile assignment. While representing juveniles, she litigated several transfer hearings in effort to keep the client in juvenile court. She's passionate about juvenile justice and serves on the Juvenile Legislature Committee for California Public Defenders Association.
Thanks, Victoria. And now we have Amelia, who will be reading the bio for Melissa.
Can you hear me okay?
Yes.
Okay. Melissa graduated from the University of San Francisco School of Law in 2013 and began practicing that winter. She started her career in civil litigation, but transitioned to criminal law shortly thereafter. Melissa has been a deputy district attorney for over 7 years, having spent 1 year in San Joaquin County and the rest of her career in Alameda. Because Alameda County is so large and serves such a diverse population, deputy district attorneys rotate amongst the various offices and assignments so that they can become familiar with the communities they serve. As a deputy district attorney in Alameda County, Melissa has held various assignments, including misdemeanor trials, preliminary hearings, felony trial staff, and is currently the vertical prosecutor assigned to the sexual assault unit. She has also rotated through the juvenile court based in San Leandro. In that role, she was responsible for all transfer hearings, adjudicatory hearings, and other various evidentiary hearings.
And lastly, we'll have Dave read the bio for Chris.
Good afternoon, everyone. Chris VanOrden has been a probation officer for the past 14 years. He currently works at the Napa County Probation Department as a probation officer and the Continuum of Care Reform Specialist. Chris was certified as a child and family team facilitator in 2015, and since that time, he's facilitated hundreds of CFTs for numerous families with various strengths, needs, and challenges. In addition to his work with the department, Chris is a trainer with the Chief Probation Officers of California, the CPOC. He has collaborated with the CPOC to deliver statewide trainings such as advanced placement techniques, advanced CFT facilitation, and successful CFT facilitation during the pandemic. Chris is also a member of the County Resource Family Approval Team. During his time on the team, Chris has created and facilitated numerous trainings for the resource families in the county, including trainings on trauma, family teaming, and coping with juvenile delinquency behaviors. Welcome, Chris.
Thank you to all our volunteers for reading those out. And now we're going to jump in. So for the panelists, these prompts have been created by the Litigation Center, but also taken from students who have suggestions, who have asked us questions ahead of time and they're interested in this topic. So, most of these questions are just going to be posed to the group, and we'd like to get the diverse perspective. And so whatever you feel comfortable answering, just go ahead and dive in. So to start off this panel, I know some students may or may not be familiar with juvenile law and how that differs from regular court. So we want to talk about the juvenile court's emphasis on rehabilitation rather than punishment. And as a second part in that, in your various practice areas, do you see a distinct difference between the focus on rehabilitation in the system, in the juvenile system versus the adult system? Because I know that, ideally that's how things should be, or that's how the courts say that things should be focused on rehabilitation, but it might not always seem that way.
So I'll go ahead and jump in here. I first did a juvenile assignment in 2013, and I started at the Santa Clara County Public Defender's Office in 2012 and was briefly in San Francisco before that in adult. And when I went to juvenile, it was so clear that the focus was rehabilitation and recognizing the impetuosity and the youthful brain as being a factor in why some of the kids were getting involved in risky behavior and getting into trouble and causing harm to the community in certain instances. And the focus was, let's figure out why. The question was why? Why did this happen? Why did they commit this crime? Why did they engage in this behavior? And that made a lot of sense to me. And so then in 2014, I started doing adult felonies, and I took all of the tools that I learned in juvenile and tried to apply them to my felony adult cases. And I remember the first time I was in a room negotiating with a district attorney at the time about what should happen in a case. And I think my client was like 20 and he was charged with criminal threats and a robbery. And I was advocating for probation, giving the backstory of this person's life, trying to explain the why. And the DA said to me, "Jen, you're not in juvenile anymore." And I was like, so it still makes sense. Like, this is still somebody who's a community member who's going to be at some point going back to the community. Why do you want to send him to prison? So now fast forward to 2022, and I have seen how the legislature has changed the law in adult to kind of more mirror what the objectives are in juvenile. This past year, there were all these bills signed into law that are now active that require the prosecution to consider childhood trauma and other mitigating circumstances, and really focus and emphasize the youthful offender brain. Science says goes up to like age 26. So the answer to your question is yes, there is a more direct emphasis on rehabilitation in juvenile. However, I feel like over recent years, I have seen it incrementally, and now more so than ever, be that way in adult as well.
I'll hop in next. So I had kind of a reverse trajectory as Jennifer, where I started in adult, did misdemeanor trials and then felony preliminary hearings. And then I went to juvenile. So I started with murders, rapes, robberies as adults. And then my next assignment was in juvenile. And the similar contrast as Jennifer had, I had, that I went from, talking about years in prison for conduct like using a gun during robbery, to then talking about how I can construct a offer for similar conduct of a kid, but to make sure that they get the resources that they need so that we don't see them as an adult. it's actually statutorily mandated that we work together to come up with the best option for the child, for the, whoever we are talking about. So it's a very stark contrast between adult court and juvenile, that it truly is trying to figure out how we can prevent seeing this kid as an adult in 5 years, 6 years, however long it may be. And I actually found that really refreshing, because at least in our county, the public defenders and the DAs sometimes have a very contentious relationship. And so when you went to juvenile, it was like it was really cool to like be able to work with your counterpart to figure out the best resolution. And it never was custody time. It was about putting things in place so that, again, we can prevent that kid from coming back.
I think it's worthwhile too, if I could just jump right in to really reflect on how the juvenile system has changed over time. I came in, 13 or so years ago into a juvenile hall in the Napa County that was designed to fit around about 50 kids. And we had 60 in the juvenile hall when I first started. Our current count at our juvenile hall right now, I think, is 6. And we get up to the neighborhood of 10 to 12, and that's a pretty high count for us, and that is a real reflection on where we're trending now. And as a juvenile system, there's a heavy emphasis on community, heavy emphasis on keeping our youth in the community. I was the camp officer for Napa County, and we had a contract for Barrow Boys Ranch where we'd have around about 10 people up there in Oregon in a camp. That facility has now closed completely because there's just no more use for it. And it's really, again, reflective of how we're approaching these issues now. We simply do not send youth outside the community like we used to. It's just not seen and done that way. We've found and continue to find that there's so much more success at finding ways to keep youth in the community, keep youth successful, and really explore not only their families, but also community members, to keep them, because their brains, as we discussed, are so fragile and still developing. And there's so much more of an emphasis now within juvenile justice on trauma, and with it being respectful to trauma, and really breaking down the silos of how we operate with all of our professionals in the county, and providing the best possible services to our youth. And I mean, it's a tremendously optimistic place to be. I do assemblies for 8th graders, which is really fun. And they ask all sorts of questions. And I walk into classrooms at times, and I think the teachers think I'm going to come in and tell horror stories about the juvenile hall. I think they're surprised. And I think a lot of people would be surprised. It's really hard to kind of give people a gauge, even, lawyers who might not understand kind of the day-to-day operation of a juvenile hall, because there's so much confidentiality at play. It's really hard to give people kind of like a visual. But it's a really supportive atmosphere, and it's never been quite like that. And I mean, it's a place where we emphasize kind of safety and helping them transition right back out into the community, and putting things in place for the youth to be successful. So it's a really fun time to work juvenile, and it's a really, you feel like you're on the cutting edge of rehabilitation and building up a strong community there.
Thank you. Now I'd like to shift. So for students who aren't as familiar with this topic of juvenile justice, can anyone on the panel speak to different types of rehabilitation options that are on the table for juvenile offenders that normally wouldn't be available for adult offenders?
Yeah, so again, this is something that currently in this very moment is really changing, and more of these types of services, depending on the county, are being made available for adults as well now. And I think that this is very county specific. So I can speak to what's available in Santa Clara County and San Francisco, but I'll turn it over to Melissa and Chris to talk about their counties. I think that in Santa Clara County, we have a dually involved youth court, where that means that the youth is not just involved in the delinquency system, but he or she may also be a dependent, which means that their parents are not in a position to care for them. So those are the kids who really get the highest level of care and services, because they're working in two different systems. There's two tracks that in our county, we try and synthesize that for them. But those are kids who might get everything from housing to therapy to mentors, RAP services. We have Fresh Lifelines for Youth, which is an organization, a community-based organization that provides extracurricular and pro-social activities. Pro-social is a term that they use in juvenile that basically means fun stuff that are, sober ways to have fun, like rock climbing, white water rafting. They might take them on trips. If the youth has issues with gang involvement, there's specific mentors and community-based organizations. New Hope for Youth is what we use in Santa Clara County that connects them to mentors who can kind of guide them through that process. It doesn't necessarily mean that they're trying to get them to drop out per se, but it's just providing them with perspective and support so they can be better equipped to make decisions on their own. RAP services is a term used that talks about there's different partners that come together and they have a team, and they might provide things from rides to school, rides to court, therapy, going on outings, taking the kids out to eat, things like that. But it really is on a needs-based spectrum. The more services the kid needs, the more services the court will give them. And that analysis is done collaboratively with the court and the district attorney and probation. But one thing I will say before I turn it over is that the defense counsel's role is somewhat unique in the sense that we have to represent our clients' express interests. There's a difference between express interests and best interests. And sometimes that becomes tricky because sometimes our clients' express interest is unrealistic and it's probably not in their best interest. And so we have trainings that we learn how to, talk to them so they can hopefully arrive at a decision that is an express interest that is in their best interest. But ultimately, if, they say, I want to go back home with my mom, I don't want to go to this group home, and we have a long talk about it, and they understand all the consequences and they understand what going back home might look like, but they still want to go back home. It's our role to advocate for them to go back home, even if it's not necessarily in their best interests.
That was a great answer. Does anyone else have anything to add, or should we move on? Okay.
I'll quickly add
Go
to,
ahead.
I think going off what Jennifer was saying is that in kind of going back to the last response, what's different about juvenile versus adult court from a DA's perspective is that we still are seeing just the police report. We don't have the conversation with the kid, or we don't have the conversation with the adult when we are in adult court. When we go to juvenile, we get to have more of a background of the kid, and we get to have reports. There's guidance reports and different evaluations that we then get to learn more about them, and then what services could be put in place for that kid. And I think what Alameda does really great, because a lot of the kids that we saw in the system do have some type of gang involvement, is that they're very involved. There's prior people who have been involved in the judicial system in the community working with those kids. And I think that those were the most beneficial, and these mentors were so beneficial for the kids to kind of help them provide guidance in an alternative way to life.
I just want to add too, again, one important emphasis, I think, in sort of our approach to providing services, and this has been a statewide initiative, and is that no longer are we doing this sort of services dump that we once would do. I mean, you would start in the courtroom just like, this kid needs substance use, he needs family counseling, he needs a cognitive group, he needs community resources, he needs to play a sport, he needs to learn you know what I mean? And you'd see the kid's eyes in court just going like this. And it's just, when does a human person have time to do all this stuff? And what we would realize is that despite our best of intentions, what we're actually doing is piling a bunch of responsibility onto a foundation of limited capacity, especially youth who have dealt with a lot of trauma. You could imagine their time management, it's not really as developed as it could be. Again, it's such an exciting time to work, and I know it was mentioned at the top of the panel here that I operate and do facilitation for CFTs, and it's a form of RAP model, where it's called child and family teaming, and we try and implement this as early as we can in the justice system, and really all it is getting the youth and the family in a room with the service providers that they're working with, and kind of seeing what is your goal here specific to the youth and to the family. What do you all want to achieve, and how can the system help you to achieve it? Through the integrated core practice model that's part of the continuum of care reforms in California, that model is built to inform the whole system, starting at the court system, as to how this family experiences success. And then we take a limited amount of services that we can provide, and provide the right services, not just all of the services to the families. And again, you're seeing a lot of success when we can set goals as a group and really learn how the individual family experiences success and how we can lend ourselves to that.
Great. So next we're shifting to differences that exist kind of post-arrest for juveniles versus adults. And I'm glad that we had this section in here, because someone already wrote me in the chat on a very similar topic. So hopefully we'll answer their question here. So can anyone on the panel explain kind of differences that exist, or that currently exist, or should be considered when dealing with the interrogation of a juvenile?
Based on current or recent changes in the law, in order to read a juvenile, anyone 18 or under, their Miranda rights, an attorney has to be present. So with an adult, you can read them their rights and they can waive their rights and agree to speak with the police. But for youth, that's no longer permitted.
And then I'm just going to jump in here because I see Dave, you raised your hand. Usually we wait for the questions, but this was so on topic that you can go ahead. I want to make sure we get your question answered if possible.
Yeah, and this is for the panel, and the law changed the last couple of years, 625.6 W&I, where police officers aren't able to not even interrogate until juveniles speak to a defense attorney. And I think it's pretty obvious that it would be not in the juvenile's best interest from the defense attorney's perspective that the kids give any kind of statement. I think it actually would be malpractice for the defense attorney to say, yeah, go ahead and talk to the cops about what you're doing. And originally it was 15 years old, now it's up to 17. So basically what that's done is tied the hands of police to get any kind of statement out of a juvenile youthful offender. And in my experience, rehabilitation only starts with a juvenile admitting what they've done, and telling the truth about what they've done. And that usually would start with the police interrogation. So I'm just kind of curious what the panel's feeling is about that. I mean, I obviously have some strong feelings about it, but I'm just wondering what your feelings are about it.
Do you have a law enforcement background?
Yes, for many years.
Yeah. So certainly there is a component of accountability and atonement that comes with a rehabilitative journey. However, we are still in an adversarial system, even in the holistic collaborative arena of juvenile court, where people are innocent until proven guilty. And so that's kind of where that comes from. And that legislation came from lots of data science research and case law that shows that juveniles are not really in a position to make a decision like that, for it to be an informed decision under the coercive conditions that are inherent with police interrogation. And so we have in my office what we call the bat phone. We take turns. Everyone has like an assignment. They have different duty days with this cell phone that when it rings, it's the police calling to see if we would like to speak with our client to see how we would like to advise them. I don't think that there's any absolutes here. I think you said something about malpractice to speak. It really depends on the situation. But when you talk about an admission being a part of rehabilitation, there is a time and a place for that. And that's with counsel in court, with information about what that admission is going to mean. And yeah, earlier I said 18 and under, but you're right. I meant 17. I meant under 18, but I think everyone knew that. If you have any follow-up questions or wait till the end, I don't know, Chloe, tell me.
Yeah, I think we'll move on if none of the other panelists want to jump in, we'll move on. And then Dave, if you still have questions at the end, feel free to jump in. That was a great question, I think, for everybody who's.
I'd like to, I'm sorry, I don't mean to cut you off.
Oh, no, it's fine. I was trying to tell who was speaking because I didn't have the speaker view thing on. Go ahead, Chris.
Yeah, I started my career as a cop, and it it informed a lot of kind of how I moved forward, and when working with the youth and youthful offenders when I was a police officer. And one thing I noticed, and one thing I continue to notice, and I started noticing as a police officer, is the admission up front. Rarely did the youth have a real understanding of the gravity of what they had done. And one thing that I'm seeing now as I'm working with the youth and their families is that some of the topics and sort of the predatory nature of what we're seeing with a lot of the young men and women that we work with, it takes a long time to develop that. And we talk about accountability, and I sort of use the example with a lot of the folks that I train is that, it's like when I was a kid, I would hear two different things from my dad. I would hear, you're in trouble, you're going to get in trouble, you're going to get punished. And then I would also hear something very different from my dad. It would be, hey, you really disappointed me. And the first one, that's the one I wanted, spank me, punish me, ground me, whatever you got to do. I just want to get it over with. The second one, though, that held me accountable to something that was much bigger to me and much more important to me. That held me accountable to my family. And that's what we really try and build now with our rehabilitation and youth rehabilitation. And on the front end, I think to the public and maybe to, a lot of folks, it might not seem that they're being held accountable. But I would assure you, and I continue to see that there's a much higher level of accountability now, where we're really building in the family and the community, and a notion of really exploring too, like, a lot of youth will just fire out a quick apology letter because it's mandated by the court. Well, that's not going to happen for a lot of us. We really take the time to kind of go in and explore, like, what are you sorry for? What are you trying to say with this letter? What do you think this meant to the person who was the victim of your crime? In a larger sense, it's worthwhile utilizing the system to really explore this. And we're finding that again, the predatory nature, if you really thoroughly and properly explore what they did and what they got into, you can really help them rehabilitate in an actual and meaningful way that will lower the likelihood that they'll commit more crimes in the future.
Thank you. Now we're moving on to specific questions pointed towards each of the panelists. We're going to start with Jen. And I know you've already probably touched on this in several of your answers, but now's the time if you have anything additional to go ahead and provide it with the panel. So are there any special rules for defense attorneys when they're speaking with minors? And what changes do you make, if any, when your client is a minor versus when they're an adult offender?
So this is kind of an interesting fact that a lot of people don't know. Public defenders and court-appointed counsel who represent juveniles have to be specially trained under the rules of court. If you look at California Rules of Court 5.664, there's specific training requirements for children's counsel in delinquency proceedings. It's also in Welfare and Institutions Code section 634.3. And it requires juvenile practitioners to have certain MCLE credits and ongoing continuing legal education around certain things that are unique to juveniles. And I'm going to just copy and paste in the chat instead of like reading it off. So you guys can kind of see how much is considered to be related and relevant to representing juveniles, because it's really quite complex. Now, private attorneys, for whatever reason, don't have to meet those requirements to practice in juvenile court. So it's interesting, to just kind of know that. Keeping that in mind, okay, I'm trying to copy it and paste it in the chat. I'll do that in a minute. When I talk to juvenile clients, or I guess when I talk to any client, I try and meet them where they're at, meet them on the level that they are at. And with juveniles, it can be kind of hard to gauge that at first. And it takes some time to get them to open up to you, like what Chris was saying. When somebody has endured a lot of trauma, they oftentimes have a history of being victimized by the system in ways, or at least that's their perception. And so as a public defender, even though I'm there to help them, I'm viewed as part of that system. And a lot of times that's met with a level of distrust. And it takes a long time to get them to really trust me. And the way that you build that trust is that you show them that you're consistent, that you don't lie to them, you don't talk to them about things that you shouldn't be talking to them about. Like I've heard some attorneys, talking to clients about other people's cases. That's a big no-no. I mean, not revealing confidences, but even just talking about someone else's cases can make a youth especially feel like you might talk about their case, even if they're not named, even if you don't name them, even if you talk about their specific situation. You don't want them to think that you're going to do that with somebody else. And so that's something to keep in mind. A lot of kids are really resilient, and especially kids who have been through a lot of trauma and experienced a lot of hardships. They come up with these survival techniques and these coping mechanisms, and sometimes they might come across a lot older than their actual age. And that's something to always remember too. The plea forms in juvenile court are designed to be understood by people who have been educated up to the 5th grade. And sometimes our kids, even though they might be enrolled in school, really haven't been educated much more past the 5th grade than even if they're in high school. So sometimes, kids slip through the cracks. They sometimes pass their classes just for showing up, and their level of understanding and cognition is actually much more below the standard than their grades might reflect. And none of that is going to be apparent the first time you meet them in all cases. And so really spending time getting to know them. And sometimes that requires multiple meetings where you don't even talk about the case at all, because you're not really going to get anywhere with the case. You talk to them about their interests. You talk to them about the Warriors, the 49ers, music, kind of staying up to date on things that are popular for their generation. I will say that, when I started in 2013, or I guess I started at the public defender's office in 2012, an adult, but when in 2013, when I went to juvie, I was much closer in age to the kids that I was representing. I went back on another juvenile assignment to do a bunch of transfer hearings in 2016. And it was only 3 years difference, but I felt so much older and so much out of touch. So now I will say to the kids, like, tell me what's cool now. Like, what are you into? There's not as much in common anymore, but finding common ground, finding things that you share with them in common. I always find something that I share in common with all of my clients, and kind of just meeting them where they're at and making sure that they know that you're there for them. As defense counsel, I think is the number one most important thing.
Thanks, Jen. Now moving on to a question that we have for Melissa. So whenever you were assigned to cases where the accused was a juvenile, was there anything different that you did in your preparation for those cases?
Not really. The burden of proof is still beyond a reasonable doubt. the rules of evidence still apply. And so everything that I needed to prove as a DA in adult court, I still have to prove in juvenile court. The only difference is that in juvenile court, the trials are bench trials. So you are presenting the evidence to the judge, not a jury. So the differences only are those in which how you present the case, because you're not trying to talk to 12 people of the community, you're talking to the judge who really already knows all of the facts because he's read the police reports. There's been lots of pretrial hearings, lots of discussions about who the kid is. So it's different in that my opening statement is it's smaller, and my closing also is smaller because I don't have to convince 12 people really. It's just the judge, who is a lawyer himself, knows the elements of a certain case, of a certain, offense, and knows how to apply the evidence to the law. But other than that, you're meeting with witnesses, pre-trying them, making sure that you know what's going to be said. You have to admit evidence. If it's a business record, you need to lay that foundation. If you're trying to get in hearsay, you need to have an exception or know how it's not hearsay. And the defense attorneys aren't letting down their guard, and I don't think that the DA is either. Again, because at this point in time, we are then trying to we're trying to have a finding in the case. So I think that we've kind of put aside alternative resolutions, and it's now at the time whether we need to figure out whether or not this person committed the crime.
Now, shifting over to Chris, I think most folks here kind of have a general understanding of what someone who works in defense or a prosecutor, what they do. But for somebody that works in probation, I think that not everybody knows exactly what that means and what kind of role that plays in the system. So can you explain more about your work with juveniles?
Yeah, absolutely. I think our role has so shifted it recently, just from a numbers perspective, because we are dealing with directly supervising far fewer youth. And just to address kind of the systematic changes that have led to that. I mean, again, I came in the department at a time where I would supervise directly coming out of the court 50, 60 youth at a school-based caseload, let's say, and that was fairly common. We would have any range of youth, and it was sort of a shock too then we started using kind of evidence-based practices to really approach who we would supervise. I mean, I used to run a program, it was like a morning boot camp style program for kids to kind of work out with them in the morning, get them involved. And it was, seen as a really positive program. And it was. The problem was, and what we didn't realize at the time, is I had, let's say, little Johnny, who's a 15-year-old who's doing, he made a mistake and he's going to be fine, and lots of parent supervision. And I'm mixing him with someone with really high criminogenic needs, and they're like making friends. And that it was kind of the kind of catch-all system that we used to utilize. And that now, I mean, what we do is we work really specifically with the youth and the families to try and cultivate, how are we going to help this youth within his or her own system experience success, and how are we going to get them out of the justice system? The quicker we can do that and the more effectively we can do that, we find that they will not find their way back by and large to the adult justice system. We have a small population that does find themselves in trouble as adults, but what we find, if we could front end a lot of services that are appropriate for the young person, and to be honest, realize when they don't need services. Some kids have made one mistake and they have a really cool family dynamic, a family that's ready to react, ready to put rules into place. And that's just a system that we all have. A lot of my job right now is to kind of reflect on that. What kind of family is this? What real needs do they have? I think a lot of us, and I know I could reflect on myself. I come from a really privileged place in which I had a family network around me saying, like, this is how you're going to experience success, and we're going to help you whether you like it or not. A lot of our youth do not have that. They're kind of out there alone in the world. And we, in some cases, we have to try and replicate that through, any number of professionals working together to help them experience success. Or they have a really great family dynamic, and we just want to help remind them of that, see that they, kind of make things right, that they might have victimized somebody or otherwise, and get them out of the system. So the intricacies of working within the system, I mean, it's a really fun thing to do. And I, with my job, I get to do so many things. It's like, it would take a lot longer than an hour to kind of go over through all the things. I mean, I'm right now, I'm doing a training on family facilitation for POs. And tomorrow I'm working in the juvenile hall because they need somebody to cover a shift. And then the next day, I think I'm going into court with one of my young people. So the amount of stuff that I get to do on a day-to-day basis, I mean, it's the coolest job in the world.
Now, I know that this has been touched on several times throughout this panel so far, but several of the speakers have mentioned how there's been a ton of recent changes. And just so we can move things along in order to have time for questions, I can summarize kind of what's gone on, but the panelists can feel free to jump in to add on because I'm no expert. But essentially, I believe it was last year, a Senate bill was passed in California that is essentially phasing out the long-term state facilities where juveniles would be housed, in order to house and treat the juveniles in more local in more local situations. So no longer being sent out to these big state facilities. Now everything's much smaller, more local. And each county, I believe, had to submit a plan for doing that and how to handle that by the 1st of this year. However, from what I've read, and we can get this input from our speakers, it's been problematic, obviously. It's a huge change. And then each county suddenly needs to adhere to these guidelines, and like how they're actually implemented is problematic. So can anyone on the panel speak to changes with this new bill passing with your specific county?
So Santa Clara County is very resource rich. And we have a huge juvenile probation department. And they were pretty quickly able to set up the secure track unit, which is what has replaced DJJ. It is not perfect. COVID makes it even more challenging. But I am familiar with the youth who are in that unit right now, and many of them, I would say all of them, seem to be doing very well and getting along, and they're taking college courses, and they are learning trades, and they get provided with therapy. And the environment in the secure track unit is, the goal is to make it feel less like a carceral setting. They have but that's really hard to do, right? It's like putting lipstick on a pig kind of thing, right? Like, it's like you still have these like metal doors that lock. And even if you don't lock them all the time, they lock. And you still have a bed that is this metal bed, this steel environment. It's really hard to dress that up. They brought in some lounge type furniture, and they tried to make it look a little bit more warm and inviting. But it's still kind of the same, it's still juvenile hall, right? And the kids are still in uniforms. They wear different uniforms. But I am really concerned about the smaller counties. So I want to definitely, I look forward to hearing what Chris is. I think Alameda is pretty resource rich too, but Melissa, I'm sure will speak on that. I really worry about the smaller counties and how they are going to come up with services. I've toured DJJ a couple of times in the last 10 years. And I was astonished the first time I went to find out how many kids were there from small counties, because they otherwise, a kid with the same type of background, because some of the kids would stand up and they would tell us about their backgrounds. If they were in Santa Clara County, they would never have gone to DJJ, because Santa Clara County is so resource rich that they would have been able to rehabilitate that youth locally within the community with RAP services and connecting them to other types of services like I discussed earlier. But in some of the smaller counties, like Yolo and Siskiyou and some of the smaller counties, they those kids' needs were beyond the reach of the county. And so they ended up sending them to DJJ. And then that was arguably harmful because, as Chris is saying, then you're commingling kids whose needs are actually lower, but the county doesn't have the resources to rehabilitate them. And now a kid who, committed a robbery for the first time is with youth who have had to endure a lot more in their life, who have maybe done some more serious things. And it isn't necessarily conducive to the rehabilitative journey of the kid who just got in trouble for the first time. And even going back before my time, it used to be the case that kids could go to DJJ for non-serious, non-violent offenses. Kids in Santa Clara County, I've been told, used to get sent to DJJ for like stealing a car. So the pendulum has been swinging in a different direction for well over a decade to move away from the knee-jerk reaction to respond to kids' needs with carceral settings and confinement. Went back when it was the youth authority, for example, and kids were being sent there for not very serious or violent offenses, and they were like totally at capacity, bursting at the seams with so many kids being sent there, to now shutting it down. For some counties like Santa Clara, it can be a good thing because the kids are closer to their community, closer to their family, and it allows for those kids to be approached individually and have an individualized treatment plan. In the counties that don't have enough resources, I'm not sure how they're going to keep up. I don't know.
Would any of the other panelists like to add anything?
Just really quickly, I have been out of the juvenile system for a couple of years, so I can't speak to how it's been changing this year. I think it's not DJJ, for everyone who's part of the seminar. That's like the child prison. They call it DJJ. In my time as a DA in juvenile, I had a caseload of only the most heinous of crimes. I had probably 10 murders on my caseload. We didn't send anyone to DJJ. And I don't know if that's just Alameda County and maybe that's the Bay Area. No one was sent. So it may be the smaller counties who maybe see less of a crime, and so they send kids to DJJ. But I have to agree that I don't know if sending a kid further away from their community is beneficial for them. So if we are keeping kids locally, but still in a way in which they can get their resources without distraction, I do think that's beneficial for the kids' rehabilitation.
One transition I've been seeing, and I think it's an interesting one, that it might address some of these concerns, even that like Jennifer brought up. I've been seeing, and again, I think the knee-jerk reaction to a lot of issues with programs is just, well, shut down the program. And I think that certainly is one way to go. We saw some years ago, that we started to transition from just your traditional group home model to now what's called STRTPs, which is a short-term residential therapeutic program. These programs emphasized a shorter program inherently, but also a program that with more focused services, more actual services. So a lot of our camp programs, Barrow Boys Ranch was a fairly well-known one up near Oregon. A lot of them shut down, and it is a shame because they had the makings of a really effective program. And what I'm seeing now, I think probably as a result of what we're discussing with the closing of the DJJ is programs that are improving rather than just shutting down, programs that are offering, even from a camp perspective, more effective services, more directed mental health, more trauma-based, trauma-focused mental health, programs that allow for the families to be directly involved in what's going on, programs that keep the families involved. Time was we would send a kid to camp up near Oregon and it's just summer vacation for the parents. They would, just kind of stop interacting in many cases and then wait, bye-bye. And then 6 months, 7 months, 8 months, year and a half later, suddenly this kid walks back into to the community with maybe a lot of new tools, like maybe we've certified this kid in welding or wildland fire, something like that, that a lot of these programs offer. And that's really great, except for they kind of somersault right back into the same broken environment, which was the reason they got sent there in the first place. So I see a lot of even camp programs now really engaging the parents and the families with their programming model and really providing not just youth-based services, but entire family-based services. And I think that trend is going to continue. Not only are we going to front end this type of philosophy, but I think we're going to kind of apply it all over. So when we start sending youth, even when we have to send youth out of the community, that they're just getting better services in general. And I think we're going to start seeing positive feedback from a lot of that, from that philosophy directly.
Perfect. And I want to make sure that we leave time for questions. So I'm going to kind of combine one of the questions that we have prepared and pose it to the group, and then we'll move on to questions from the attendees. So, and this is posed to each of the speakers, and we'd like to answer all separately. What is the most challenging part of working with juveniles in your respective role? And then also, what are your hopes for the future of the juvenile justice system?
I can lead with this one. As I was saying earlier, as a DA in the adult court, you see the police report, you see the person in court, and that's all you get to really know about, unless a defense attorney presents you with mitigation and tells you a little bit more about the defendant. But then you aren't, statutorily obligated to really even take that in consideration if you don't want to. When you're in juvenile, you get to know about these kids, and it's where they came from, how they grew up, what they have gone through. It's heartbreaking. It's the things you can't even imagine that they've had to experience before they got to where you're at. So you see that, and then you see what they do, that they are putting a gun to a 65-year-old woman's head. They knocked her teeth out. They murdered somebody. And it's a struggle as a DA to figure out what is best for the community. This woman, who's never going to go to that community again to serve, as a nurse because of what this kid did, versus this kid has so much trauma in his life. You can't really blame him. And so that was the most difficult part for me as a DA, is trying to reconcile those two. And giving chances and hoping that you would never see them again. And I think the most rewarding part is when you don't see them again, is that when you see a kid who did something bad, who gets early intervention, and then they would do progress reports even years out. And you see that, he's now has straight A's, or he's engaged with his parents, or he's on the star of a soccer team. And when they are finally released from, they have no future court dates, so you do kind of a graduation for them, and everyone gets up and claps. And I think those are the times where you feel like, hopefully, you took this person out of the trajectory that you won't see them again as an adult.
So what I find to be the most challenging is the inability to help my clients. And, as a defense practitioner, I get to know their whole family. If they don't have a family, I get to really absorb the fact that they're really all alone for the most part. And at the end of the day, I go home and they go wherever they go. Sometimes that's home. Sometimes they live in a car. Sometimes they go back into juvenile hall. Sometimes they go back to a group home, and I become enmeshed essentially in their trauma. And that definitely results in a lot of secondary trauma for defense counsel. And you could do a whole other training about that. But the first time that I did juvenile, I was doing that calendar, the dually involved youth calendar, where the parents had lost custody. And then my client had also been accused of crime. And it was just devastating and heartbreaking. I remember a time where a mother came in and she had the little siblings with her in court, and their little feet are dangling on the chair while, I'm representing their older brother. And the backstory in that case was that my client was from a different dad, and she had such animosity towards that man. And my client looked so much like his father that she had so much animosity against my client, her son. And in the middle of a court hearing with all the little kids sitting there, she raised her hand. This was not one that was a duly involved, but it probably should have been. She raised her hand and asked if she could terminate parental rights right now. Like, she just wanted to wash her hands of him and go on living her life. And it crushed my soul. It crushed the DA's soul. Like, the judge was furious, and he was trying to maintain his decorum. And he, told her this is not the appropriate venue for that. But my heart just broke for my client, because all he wanted his whole life was for his mother to love him and accept him. But she couldn't get past her trauma, couldn't get past the fact that he was a constant reminder of an abusive relationship she had. And that resulted in him, having a lot of issues. And it's like this impossibility. It's this desire to want to help. It's this desire to want to bridge the gap. It's this desire to want to make sure that they know that they're loved and that they matter and that they're respected. But it's the inability to really close that loop that I find to be the most challenging part of juvenile. I don't go home with them, and I can't save everyone. And that's the hardest part.
I would say, the most challenging part of my job is working with attorneys. No, just kidding. So it's hard to tell if people are laughing on the Zoom. No, quite the opposite. I talk a lot about the family teaming meetings we do, and again, some of the most successful meetings I have and I've had these, is where the attorneys from both sides of it, I have people from the public defender, people from district attorney, they can be at the meeting. And there's something about having just kind of a group of folks really talking and kind of empowering the youth, and really everyone in that realm putting their agendas aside. I harp on it, breaking down all the silos, and just focusing on kind of what the goals are for the youth and the family. I'm surprised, and I think we all are surprised by how productive some of our young people can be, how productive some of these families can be when we allow them to kind of speak from their own experience and talk about their strengths, because they do have strengths. These are people that have survived quite a bit in so many cases, people that have overcome so much. So the challenge of breaking down those silos and kind of my day-to-day, it's a challenge, but it's so rewarding. It's so rewarding for what we do, and the benefits of it are just endless. So that for me is a big time perk of what I get to do.
Thank you so much to all of our panelists. We're right at 1 o'clock, so we might have time to squeeze in maybe just a few questions if anyone has a question they would really like answered, and then we'll do our raffle really quickly. So feel free to unmute and ask your question, or if not, we can just move on to the raffle.
I guess oh, sorry, Olivia. I had a question. As far as you're talking about the relationships that you can have with your clients with juvenile, like how far can you go with that? As far as, say you see an abusive family member, like where can your impact, can you go as far as trying to get them away from that, instead of, and like you're still fighting for them in the courtroom, but also fighting to help them get away from an abusive mother or father or what have you?
Public defenders aren't mandated reporters, and we have an obligation and duty of loyalty to our client, which is complicated in the context of a juvenile, right? But like I was saying before, we have to represent their express interests. So sometimes that means that we don't report any kind of abuse because it was told to us in confidence and it's part of the attorney-client privilege. I definitely have had situations where there was something to say potentially, but my client asked me not to, and I have to respect that.
Okay, so yeah, there's not much of like working with child protective services or anything like that. It's really.
So sometimes they come to me like that. So sometimes when they're duly involved, they've already been taken away from their parents. But even in that context, if they are advocating to go back home to their parents and I have an informed discussion with them about what that might look like and how that might get in the way of what they're trying to do with school, or, acknowledge all the progress that they've made. And remember last time when you were living with your mom, this happened and that happened. What if that happens again? And they might change their mind, but if they say, no, I hear you, but it's going to be fine, I want to go back home with my mom, the defense attorney's role is to advocate for that.
Okay, thank you.
Yeah, and that, again, that's another thing that's really hard. It's hard to do that in certain situations.
And lastly, I think we have a question from Olivia. Go ahead, Olivia.
Yeah, maybe a good one to close it out with. If you are trying to maybe get involved in the juvenile space, what do you think are good first steps or first kind of goes down the path of being involved in that space and getting to know more about it?
Interning, either with the DA's office or probation or the public defender's office, and trying to get a specific internship in the juvenile unit.
And if you become like a DA, I know that you can request, at least in our office, if you're passionate about it, you can always say like, this is the area that I would like to go to. And because it's not a good fit for everyone, they respect that and would love to have someone work who wants to be there.
We're hiring juvenile hall staff right now. I don't know what you're up to tomorrow, but are you busy? Can you work a shift or? I just
A little busy, unfortunately.
all right.
Thank you for the option.
We'll get you.
Okay, before we wrap it up with our raffle, someone wrote me in the chat and they asked if the panelists are comfortable, would they leave their contact information, like their email in the chat, so that people can reach out if they have more questions. So panelists, you're not obligated to, but if you feel comfortable with that, could you drop your email in the chat? And in the meantime, I'm going to do our raffle. So this was totally not planned, but Jen actually mentioned this organization at some point during this panel, but we had selected Fresh Lifelines for Youth for our raffle donation. And for those of you who don't know, so they're a big organization and they have a lot of different programs that fall under their organization, but they service mostly Bay Area counties. For example, one thing that they do is they have a reentry program, which helps folks who are juveniles who are moving from being incarcerated back into the communities, and focuses on things like case management, mental health services, classes on how to deal with any kind of emotional issues that are going on, that sort of thing. Another example of something they do is they have volunteers who are trained go into different places like schools and there's different locations. I can't remember off the top of my head, but they go in and they give education and classes on things like, police encounters and what to do. And they really focus on educating people to try and keep them away from these types of situations. So those are just two examples of something that this great organization does. And for our raffle, we're going to select 2 attendees and we're going to donate, make donations in your name to the organization. So Professor Brockle, pick a number between 1 and 26.
Oh, let's do my favorite number 8.
Okay. That's Peyton. So Peyton, you will be one of the recipients. So we'll make a donation to Fresh Lifelines for Youth in your name. And then one more number, Professor Brockle.
Oh, let's do 11.
And Daniela. So Daniela, you will be our second recipient. So thank you guys so much. Thanks for our panelists for speaking. It was very interesting and exciting for all of the attendees, I'm sure. Thank you so much.
Thank you, everybody. We'll see you at the next event.
Thank you.